Hi, welcome back. In this next lecture, we look at the American judicial system. Now, I said early on that what we are doing in this first module of the course is focusing on procedure, specifically dispute resolution. How are disputes resolved? And in the United States, most disputes are resolved through use of the American judicial system. Now, when we talk about the American judicial system, we're really talking about a collection of federal and state courts that exist primarily to adjudicate disputes, to resolve disputes. So, disputes often arise in business situations. It could be a breach of contract, whether a party kept its promise given in a contract. It could be in the sense of a loan that was not repaid. It could be in the sense of a negligence case in which a business harmed someone and there was a question as to whether the business should be liable, and if liable, then by how much. So disputes often come up in business situations. And as I mentioned, it's the judicial system that provides the primary means of dispute resolution. Now, when we start a claim for relief, we do that by filing a lawsuit in court. And so what we will be doing in the first module is to be focusing on the lawsuit, the practicalities, not so much on the substance of the law, but the procedural aspects of the law. And the reason we do this is this idea that sometimes a business must do a cost-benefit analysis of a case which is independent of the substantive aspect of it, simply to say, is it worth our time and money to resolve this case in court, or would we be better off settling early? So business managers that are focused on resolving disputes have to learn certain legal fundamentals. And in this lecture, we're going to examine the American court system as well as legal concepts such as jurisdiction to understand how courts work to resolve disputes. We begin by looking at an overview of the judicial system, starting with the role of the judiciary. What are that collection of state and federal courts doing? Well, courts in the U.S. exist to resolve disputes. Courts in the U.S. play a key role in interpreting and shaping the law. Oftentimes, the statutory law passed by Congress or by a state legislature is open-ended and without a lot of detail. Sometimes we have executive agencies to help fill in those gaps, but oftentimes we turn to the court system. What does it really mean? For instance, again, when we cover employment discrimination, we're going to focus on a statute called Title VII of the Civil Rights Act of 1964. Now, Title VII simply says it is illegal to discriminate on the basis of membership in certain protected classes: race, color, sex, national origin, and religion. And that's about the scope of the statute. So what does it mean to actually discriminate, and what are the defenses that an employer has? Well, all of those have been given to us through the common law, through court decisions. So courts in the U.S. play an outsized role in the law. Furthermore, courts in the U.S. have the power to review acts of the legislature to ensure that they're in accordance with a constitution, either the state constitution or the federal constitution. This power is called judicial review, and it is essential to how our system operates. So a court, any court, has the ability to examine a statute and to determine whether that statute falls within the bounds of the appropriate constitution, whether that's a state or the federal constitution. So judicial review is a power held by the American judicial system to determine whether laws conform with the Constitution. So when you hear stories or read stories about unconstitutional laws or about the Supreme Court deciding the constitutionality of the law, what they are really doing is focusing on, did the legislature have the power to enact this law? Does this law comport with the Constitution? Now, the United States has a divided court system. There is a fundamental division between state courts and federal courts. So when we talk about the American judicial system, we can't really say that it's one system of courts or two system of courts. Instead, it's really 52 different judicial systems. Every state has its own judicial system, including the District of Columbia, and the federal government has its own judicial system. Now, oftentimes, these courts overlap in the types of cases they can hear. So there are some broad divisions, however. For instance, state courts tend to focus on state laws, on state constitutions, and on the common law of the state. Every state has its own version of the common law, such that the law of Kansas is different than the law of Washington is different than the law of Louisiana. So state courts in each of those states will address issues of state law and create common law out of their decisions. Federal courts are focused generally on federal laws, the U.S. Constitution in particular, but also between citizens that live in different states. We call this diversity of citizenship, and a federal court has the power to hear any case involving citizens of different states. But one important restriction on this is that every entity involved in the lawsuit must be a citizen of a different state. Let's start by looking at state courts. State courts generally have a three-tier system, and that system is going to be made up of trial courts, courts that hear the initial version of the dispute at the lowest level, and then there is generally a system of appellate courts at the second tier, and then the highest tier is made up of the state Supreme Court, although in certain states like Texas you actually have two Supreme Courts, one Supreme Court for civil matters and another for criminal matters. But let's talk first about the trial courts. The trial courts, state trial courts, are the backbone of the American judicial system. They are the heart of the American judicial system. Most disputes are going to be brought in state trial courts. The vast majority of cases are brought in a trial court within the state. And the trial court has one very important function, which is to determine the facts of a case. The trial court has the power to determine what actually happened in the dispute. So if you have a car wreck case in which one party says the light was green when they were driving through, and the other party says no, its light was green when they were driving through, it is up to the trial court to decide who had the green light, which party was justified in going through that intersection. That's an example of a fact. If it is a question of a breach of contract in which one party says they were not repaid or they were not repaid enough, then it's going to be up to the trial court to determine how much was paid, whether it satisfied the requirements of the contract or not. So trial courts determine the facts of the case, and generally it is the jury's role to determine these facts. And so we often refer to the jury as the finder of fact. Now, many times litigants would generally prefer to avoid going to a jury trial. And so sometimes you will see the judge take on the role of the finder of fact. So the judge will actually do the same work as the jury does. But in any event, state trial courts decide the facts, and those facts cannot be changed by an appellate court. Whatever the facts of the case are at the time that the trial court hears it, those facts remain the facts for the rest of the life of that suit. So trial courts play a very important role. If you ever wind up on a jury, take your role seriously. Don't simply try and avoid it, because what you're doing is you're going to decide facts, and those facts are the final decisions. Now, there are different kinds of state trial courts, starting with general jurisdiction courts. They have broad authority over various types of cases. This is generally called the district courts. In Texas, for instance, there are multiple district courts across the state, and each of those district courts has jurisdiction over any number of different types of civil cases. There are also limited jurisdiction courts, which will have a more specialized focus. For instance, small claims courts. Now, again, I'm a Texas lawyer, so in Texas, small claims courts are referred to as justice of the peace courts, and justice of the peace courts can hear any claim up to $10,000, but cannot hear a claim more than $10,000. So these courts are limited in their jurisdiction by what we call the amount in controversy. So small claims courts can hear any case as long as the amount in controversy is less than a certain amount, $10,000 in Texas. Many courts are devoted only to family issues. So there are family law courts that will hear matters, usually divorce, but also things like adoption and other related family law matters, guardianship, family courts. And that's the only kind of cases that those courts hear. But they are still acting as a trial court. They are deciding facts. Probate courts, they hear matters regarding wills and estates and trusts. Again, they are the trial court for those specialized matters. Now, an aspect of state trial courts that you should know, because it's important, is that many states have elected state court judges. They are elected by the people. They run for office just as if you were running for sheriff or for mayor or for the state's representative. This can lead to problems, obviously, right? There's a built-in problem in that if you are involved in an election, then you have to go raise money, and you have a situation in which every judge should be doing the same thing. So it's hard to distinguish yourself from other judges. Now, in Oklahoma, these elections, these judicial elections, are nonpartisan, meaning we don't know what party the judge belongs to. But in a state like Texas, they are partisan, and you run for judge as a Democrat or a Republican or a Libertarian, and that's how it appears on the ballot. The problem with that is that many times voters don't know who the judges are, and they tend to vote solely on political party, which can lead to wild swings in the makeup of the judiciary if there is if there's a substantial difference in who shows up for that particular matter. For instance, in the year 2000, when George Bush was elected president, every Republican judicial candidate won, every Democratic judicial candidate lost in Harris County, where I was practicing at the time. In 2008, it completely reversed, wherein every Democratic judicial candidate won and every Republican judicial candidate lost. So good judges, bad judges, it didn't matter. It was all based on party affiliation. And that's a cause for concern. Appellate courts. Appellate courts hear appeals from trial courts, meaning when one party, or sometimes even both parties, are dissatisfied with the results of the trial court, they can appeal that to an appellate court. However, the appellate court can only decide matters of law, legal matters. The appellate court does not have the power to change the determination of the facts of the case. So the types of legal issues that are usually addressed are things like, did the judge exclude evidence that should have been admitted? Or did the judge admit evidence that should have been excluded? Or were the judge's instructions to the jury proper? Those are all legal matters, and an appellate court has authority over all of those. Now, once the appellate courts generally hear cases in groups of 3. So there will be 3 appellate court judges that hear the case. And then they will vote, and whoever has the majority will then write what's called an opinion. So the court will issue a written document called an opinion, a judicial opinion. And as I mentioned in the last lecture, these opinions become the law. They become the law for all future cases involving similar facts and issues as the case at hand. Now, an appellate court opinion becomes a precedent. So every trial court within the jurisdiction of that appellate court is bound to follow that rule. And so if you have a situation where the appellate court is actually the Supreme Court, then the decision of the Supreme Court will affect all future disputes in that area. So the decision of the appellate court becomes the law, and trial courts have to follow those decisions when they are set by superior appellate courts. This adds the predictability and the stability that I mentioned in our first lecture. Now, the precedent can only be undone, changed, reversed by a superior appellate court. In the matter of state courts, that is generally the state Supreme Court. And once the state Supreme Court issues its opinion, then every trial court and every appellate court in the state will be required to follow that opinion. Now let's look at federal courts. Federal courts have limited jurisdiction, but can be very powerful. Now, before we start talking about federal courts, I should mention this very important fact that if you were to design a judicial system to be as complicated as possible, as convoluted as possible, and to be as least cost efficient as possible, you would devise a system somewhat like the United States it has. Because this question of whether a dispute should be heard in state court or federal court results in a great deal of litigation, money spent, time spent, hours spent to determine who should hear the case, which court has the power to hear the case or should hear the case. And so you probably have no idea how much time and money goes into these factors, which have nothing to do with the substance of the case. Now, federal judges are not elected. They are appointed by the president, and then they must be confirmed by the Senate. So generally, although this is supposed to be a nonpartisan procedure, when there is a Democratic president, the judges who are appointed are favorable to the Democratic Party and Democratic members. When a Republican president is elected, the appointed judges are invariably Republicans or people who are sensitive to Republican issues. So even though this is a nonpartisan procedure, it is in effect partisan. Federal judges have lifetime appointments, meaning once you are confirmed as a federal judge, that job is yours pretty much for as long as you want. There is a procedure for impeaching a federal judge, but that has been rarely used during the 250 years of American history. So essentially, when a federal judge is appointed, they can keep that job for as long as they want to keep it. The idea being is we don't want a judge who is subject to political factors, who has to run for re-election, who must take money from one side or another. Instead, this is the idea that we want people to be the best possible judges that they can be. Now, federal courts are also structured in a three-tier system. And at the bottom level are U.S. district courts. Above them are circuit courts of appeals. And above them is the United States Supreme Court. So let's look at each of these in turn, starting with U.S. district courts. Every state has at least one U.S. district court, but generally states have more than that. In Oklahoma, we have 3 different U.S. district courts. In Texas, there are 4 U.S. district courts, but even then, those courts may have multiple judges. District courts, U.S. district courts, tend to hear cases involving federal law. So federal criminal matters are generally brought in federal court. Cases involving the federal statutes can be brought in federal court. So again, with discrimination cases, for instance, because that is based on a federal statute, Title VII, a plaintiff has the right to bring that case in district court. Now, they also hear cases involving citizens of different states. And when the federal court system was created, one of the justifications for creating a separate system was this idea that a resident of Delaware should not face a disadvantage by going into court in Maryland, for instance. And so the idea of federal courts was that it would not matter the citizenship of the individual parties. Now, this is not so much what it is used for these days. Instead, it is for to protect people, out-of-state defendants, by allowing them to be in a more conservative, generally conservative system like the federal court system. U.S. Circuit Courts of Appeals. Now, these are intermediate appellate courts in the federal system. So again, every state has at least one U.S. district court. And then the states are then geographically divided into 13 different circuit courts of appeal. So for instance, in Louisiana, which is where I'm from and where I was originally practicing, Louisiana is subject to the Fifth Circuit Court of Appeal, along with Texas and Mississippi. So these circuit courts of appeals will hear cases based on geography, essentially. They hear cases brought by the appellant, and that's who the party that is seeking relief from the trial court's judgment, against the party called the appellee. And the appellee is the party against whom relief is sought. So when you see a case name involving a circuit court opinion, invariably the first name is the appellant and the second name is the appellee. Now, the appellant may have been the plaintiff in the trial court, it may have been the defendant, but in this case it is the appellant because they are the party seeking relief. Finally, the U.S. Supreme Court, the ultimate authority on federal law, their jurisdiction, however, is limited to matters involving federal law. That state Supreme Courts remain the final authority on state law. So the state law, the Supreme Court of Oklahoma is the final authority on Oklahoma state law. The federal U.S. Supreme Court can only decide matters of federal law. Now, they have a very limited caseload, meaning they only hear a small percentage of cases that are appealed every year. Now, the intermediate courts of appeal must hear every case. They must hear every case. However, the Supreme Court does not have to hear every case that is appealed. And it is the same for most state Supreme Courts. In the U.S. Supreme Court hears approximately 3% of all of the cases that are appealed to the U.S. Supreme Court. So if you ever hear someone saying, I'm going to take this all the way to the U.S. Supreme Court, that's probably not accurate because the Supreme Court is probably not going to hear that case. They only hear a small fraction of cases, and those cases tend to involve significant legal issues. Oftentimes, it's a matter of a difference between the circuit courts of appeal, where the Fifth Circuit has ruled one way and the Sixth Circuit has ruled the other way, and therefore the Supreme Court must come in to harmonize the law between these conflicting courts of appeal. So, for instance, in the situation of same-sex marriage case that was decided back in 2015, that case was brought because there was a split in the circuits, that in the Fifth Circuit, for instance, same-sex marriage was illegal. In the Sixth Circuit, same-sex marriage was the law of the Sixth Circuit. So to harmonize those cases, the Supreme Court took one of those disputes and decided it in favor of same-sex marriage, which then now becomes the law for all states. Next, we turn to jurisdiction. Jurisdiction is really the most important concept in the law because jurisdiction involves the power to hear a dispute. That a court cannot hear a dispute unless it has jurisdiction. Anything that a court does, if the court doesn't have jurisdiction, is meaningless. We call it a nullity. Any decision made by a court that did not have jurisdiction over the dispute is immaterial to resolution of the dispute. So jurisdiction is really the most powerful concept of the law because it involves a court's power to hear a case. A court's opinion is meaningless if it did not have jurisdiction over the issue or the people involved in the dispute. So there are two aspects to jurisdiction. There are two types of jurisdiction, and both types must be present for a court to hear a case. So what you will need to know for your test is the two types of jurisdiction, but also keep in mind both of these must be present in order for a court to hear a case, in order for a court to have jurisdiction. We start with subject matter jurisdiction. Subject matter jurisdiction refers to the authority over the dispute itself, over the nature of the dispute. Whenever a court is created, that court is given jurisdiction over certain types of disputes, and we call that subject matter jurisdiction. Now, the other type of jurisdiction is what we refer to as personal jurisdiction, which is authority over the parties that are involved in the case. Subject matter jurisdiction, personal jurisdiction, both must be satisfied in order for the court to issue any ruling in the case. Let's look a little more in detail at subject matter jurisdiction. Now again, for state courts, for your state trial courts, they have broad authority over state law issues. As I mentioned, a district court in Texas can hear pretty much any dispute, regardless of the amount in controversy. It could be $1,000, it could be $1 million. The court still has authority over that. So anything having to do with state law, state courts, even at the trial court level, have jurisdiction. Now, it becomes more complicated when we are looking at federal courts. And one of the reasons why I said that our judicial system is so complicated has to do with the limited jurisdiction of federal courts. Federal courts are limited to three types of cases. First of all, those involving federal questions, which tends to be federal laws, situations about federal laws, controversies about a federal law, whether it is OSHA or anti-discrimination or the Fair Labor Standards Act. The federal court has jurisdiction over that issue. They also have jurisdiction over any dispute involving the United States as a party. So if you are to sue the United States as a party, that case will be heard in a federal court. The final type of case that they have jurisdiction over are those diversity cases, those citizenship diversity cases that we mentioned. Those cases that involve citizens of different states. Now, the final thing we have to look at is really the reason why I say the American judicial system is so complex. And that has to do with the matter of concurrent jurisdiction. Oftentimes, multiple courts will have authority over a particular dispute. Multiple courts will have both subject matter jurisdiction and personal jurisdiction. And when multiple courts have authority, oftentimes there is a question as which court should hear the case. So even though a case may involve citizens of different states, even though it may involve a federal question, it may still be heard in state court. For instance, every state has an anti-discrimination law similar to the federal Title VII. if I am to bring a dispute involving a discrimination claim, I can cite both the state law and the federal law, which then gives me access to the state court. So concurrent jurisdiction and determining which court is the best court to hear a case can be very complicated and expensive. Let's look at personal jurisdiction. Personal jurisdiction refers to the power to hear a dispute involving these particular parties. Who are these parties? Now, if both parties are resident of the same state, it is pretty easy to establish personal jurisdiction, meaning both parties are citizens of the state, and therefore we can hear a dispute. Now, the problem that arises is when there are out-of-state defendants. How can a court exercise personal jurisdiction over an out-of-state defendant? Well, that is accomplished through what are called long-arm statutes and a concept of minimum contacts, which says that sometimes a state court can exercise a jurisdiction over an out-of-state defendant if the state has what's called a long-arm statute, and virtually every state has this, and if the party that is sought to be brought into the case has certain minimum contacts with that jurisdiction. This is a very complicated area, so I'm just going to give you the broadest possible overview. This is an area that is heavily litigated each and every year. This question of did personal jurisdiction exist? It is very difficult to say 100% of the time whether it existed or not. So we have to look at this question of minimum contacts. Did the party that is being brought into the case, the out-of-state defendant, did they have minimum contacts with the state in which the court is based? Now, one thing that we can look at is what's called purposeful availment. Did the defendant, and generally these are defendants who are being brought into this case, did they take actions in the forum state, the state that is going to hear the dispute? So if we have a situation where a Texas resident is buying goods from a Florida resident, we have to decide, did Florida make a special effort to reach into Texas to engage with the Texas resident? And so we look to see what sort of acts did the defendant take in the state. Were they simply a defendant that had a website that was available to everyone in the country or in the world? Or did they make a deliberate effort to market their goods in Texas to the forum state? We also look to see at injurious effects. Did the defendant's actions cause harm within the state? Did the out-of-state's defendant's acts cause harm within the state? So if we have a situation where there's a car wreck involving two people driving in Oklahoma, and one of the drivers, the plaintiff, is a resident of Tulsa, Oklahoma, and the other driver is a resident of Wichita, Kansas, can we sue that Kansas driver in Oklahoma? In this case, probably yes, because first of all, the accident took place within Oklahoma, and therefore the defendant's negligent driving caused harm within the state. You could also argue that the Kansas driver had availed itself of Oklahoma roads and therefore was subject to being brought into a court in Oklahoma. Finally, we look at questions of reasonableness. Is it fair? Is it just to expect the defendant to defend in that particular case? Is it fair? And most long-arm statutes, when we talk about what is the extent of a long-arm statute, the extent of the statute is limited by the question of due process. Is it fair? Is it fundamentally fair to bring this particular defendant into a state, making that defendant defend a case, hire a local counsel, bring itself perhaps for the trial to the forum state? Is that fair or is that just? And of course, this problem has been exacerbated by the internet, that suddenly business, which at one time was primarily local, has now become nationwide. And so this question of, if I buy goods from based on a website that I'm able to access, and is it possible that I can bring that company into my forum state even though they may be residents of Washington or Oregon or Florida? Now, there's a case, and the details of the case don't really matter, but we call it the Zippo case. It's the Zippo Manufacturing Company versus a company called Zippo.com. And in that case, the court developed essentially a sliding scale for evaluating minimum contacts. And those minimum contacts are based on the notion of interactivity. So on one end of the scale, you have a passive website. I have put up a website advertising my own goods. The goods are stored in my state. I am registered in my state to do business. I just have a website that is available to everyone. In those cases, probably no jurisdiction. There's been no purposeful availment of the forum state. Instead, there's simply a passive website. In the intermediate aspect, we look to see signs of interactivity. Was there a sales process, for instance? Was there something that enabled a contract to be entered into, to be reached? And so this invariably involves a case-by-case analysis, meaning it's tough to state exactly whether the defendant company had availed itself of the foreign state or not. Finally, if it is integral to the business model of the company, then there is likely jurisdiction. So a company like Amazon, which has very few physical locations, Amazon does business as a .com. They are doing business over the internet. Amazon fully expects that people from Louisiana and Kansas and California and New York are all going to access its website. And so in those situations where the business's model requires website interactivity, then we are likely to see jurisdiction. Venue. Now, venue is something that we hear about, and oftentimes venue and jurisdiction are confused. But when it comes to jurisdiction, remember, jurisdiction refers to the power to hear a case. Does a court have the power to hear that particular case? Venue, however, is based on the notion of geography. Which is the appropriate location for the trial to be heard? So if it is a case involving state law and involves one resident of Tulsa and one resident of Oklahoma City, well, which court should hear that case? A district court in Oklahoma City or a district court in Tulsa? Now, venue is typically determined by where the defendant resides, meaning venue is going to be most proper in the district in which the defendant resides, or where the events occurred. Now, venue is also permissive, meaning even if venue is not proper, even if one particular location is not the most appropriate location for the case to be heard, the parties can agree to have the case heard elsewhere. So, for instance, when I practiced in Austin, Texas, Austin is in Travis County, and right to the north of that is Williamson County, and oftentimes residents of Williamson County did business in Travis County. They worked in Travis County. They had their business based in Travis County. They simply lived in Williamson County. In those situations, oftentimes when I, residing in Travis County, sued a defendant in Williamson County, they preferred to have the case heard in Travis County. So we were able to agree to the venue. Venue always requires the existence of jurisdiction. Parties cannot agree to jurisdiction. They can, however, agree to venue. And what we've seen in recent years is oftentimes in a contract, in the terms of the contract, the parties will agree to venue in advance. And so if you want to sue Facebook, for instance, in the terms and conditions you agreed to when you opened your Facebook account, you probably agreed to a venue in California, meaning you can bring your case, but it must be in a California court. And generally, it will be specific. The final thing we'll talk about in this lecture has to do with the problem of forum shopping. Forum shopping refers to a very common strategic tactic by plaintiffs in civil litigation, that a plaintiff wishing to bring a lawsuit is aware that there are more favorable venues available. And so if you have a situation in which there are multiple courts that will have jurisdiction, you, as the plaintiff, may prefer to be in a certain court. And so you may file your suit there, even if it's not the most appropriate location, but if you can argue it is. So when it comes to forum shopping, we often see cases heard in a forum that really didn't involve the dispute itself. I was once in a case involving a claim of mesothelioma. Mesothelioma is a type of cancer that is only caused by asbestos. That asbestos is the only source of mesothelioma. Mesothelioma does not occur without exposure to asbestos. Now, this case involved a resident from another part of the country. However, they brought their lawsuit in Brazoria County, Texas. Now, why did they do that? Because Brazoria County is the home of Dow Chemical Company, and Dow Chemical Company originally produced asbestos. So even though the plaintiff had no relation to Texas at all, had never worked in Texas, had never been involved in Texas, nevertheless, they are able to bring their claim in Brazoria County. And they do that because they know there are favorable juries available in Brazoria County. And this is a tactic that is that bipartisan. You know, oftentimes people will bring cases, for instance, in the southern part of Texas, what we call the valley, the Rio Grande Valley. And juries in that area are typically very predisposed to plaintiffs. And so if you can somehow get jurisdiction and venue in the Rio Grande Valley, you will choose to do so. At the same time, if you have a conservative issue, you tend to go shopping for a conservative judge. For instance, there have been a number of lawsuits in recent years, things involving national issues like immigration or abortion or LGBTQ rights, that have all been filed in the Amarillo division of the Northern District of Texas. Why is that? Because there's only one judge that will hear that case, and that judge is going to be very predisposed to your position. And so we see forum shopping constantly, and it is legal. The only question is it ethical? And we'll take that up when we talk about business ethics. Is it ethical to go forum shopping? Is it injurious to the judicial system as a whole? Because what it means is that you believe an outcome can be better in one court than in another. So, in conclusion, what did we learn in this lecture? Well, we learned that state courts are the backbone of the judicial system. We know that federal courts are powerful, but have a limited reach, and jurisdiction involves the power to hear a case, the most important concept in the law. Thanks a lot for listening. I know this was a lot to take in. As always, if you have any questions, let me know. Enjoy this video, and I will see you in the next one.